Chairman. Mr. Smith, you've said several times in your deposition that you believe that the facts and the law, your interpretation of the law, would lead to a conviction of President Trump. Is that correct?
Yes.
And did you believe that same thing, that your interpretation of the law, your reading of the law, would have resulted in the conviction when you went after Virginia Governor Bob McDonnell back in 2014?
This Republican lawmaker tried to put the American justice system itself on trial by putting special counsel Jack Smith in the hot seat. But the exchange instead reveals how uncomfortable Republicans are with the idea that the law might apply to everyone, including presidents.
Did you believe it at the time?
I did believe, and
ultimately you got a conviction in lower court, but that was overturned by the Supreme Court, correct?
Yes, the Supreme Court changed the law on what constituted an official act. And
Actually, that's incorrect.
That conviction was overturned.
That's incorrect. They applied the law, and they said in their ruling, our concern is not with tawdry tales of Ferraris, Rolexes, and ball gowns. It's instead with the broader legal implications of the government's boundless interpretation of the federal bribery statute. A more limited interpretation of the term official act leaves ample room for prosecuting corruption while comporting with the text of the statute and the precedent of this court. They accused you of using a boundless interpretation of the federal bribery statutes. Now, did you believe when you went after John Edwards that your interpretation of the facts and the law were correct and that you would convict John Edwards of corruption?
Yes.
But in fact, that case resulted in a jury deadlock on 5 charges and acquittal on another charge. Is that correct?
That is my recollection. That's correct.
Let's move on to the court's interpretation of your gag order requests. Mr. Smith, America was founded on the principle that the government doesn't silence political speech, in particular speech before it happens. You sought a prior restraint against President Trump without a single violation of pretrial release. In fact, there was no real-world harm that you could articulate justified giving the federal government the power to silence him as a presidential candidate, was there?
The court granted those motions and found that the prosecutor did not have to wait until someone was harmed to make such a motion.
Actually, the request was rejected when the case was actually, when you actually were not able to, it was restricted, correct? The gag order was restricted, correct?
Well, we filed for an order in the district court. The district court granted an order. President Trump appealed that order. The Court of Appeals absolutely agreed that there was a basis and that the threats to witnesses that came from the targeting by Donald Trump were real and that we had a duty to protect them. You are correct in that the Court of Appeals narrowed the order, so the order covered witnesses, court staff, the judge, and my staff. The difference was that it didn't cover me anymore, which I was fine with.
Did you have any evidence that President Trump's statements about the cases against him intimidated witnesses or prevented them from coming forward?
I had evidence that he said, if you come after me, I'm coming after you. He suggested a witness should be put to death. The courts found that those sort of statements not only deter witnesses who've come forward, they deter witnesses who've yet to come forward.
But you weren't able to identify a single witness who didn't come forward because they were intimidated by President Trump.
We had extremely thorough evidence that his statements were having an effect on the proceedings that is not permitted in any court of law in the United States.
Don't you think it's a pretty low bar to clear if you're trying to silence a candidate for president? I mean, if you can't identify a single witness who's intimidated, that maybe you should reconsider the gag order?
Both courts upheld the orders, and it is not incumbent on a prosecutor to wait until someone gets killed before they move for an order to protect the proceedings.
Did anyone on your team raise concerns that this expansive gag order you were seeking would infringe on President Trump's First Amendment rights?
My recollection is that we, of course, discussed First Amendment issues regarding this application because I and my staff respect the First Amendment, but the First Amendment does not allow one to make statements that interfere with the administration of justice in a judicial proceeding. My interpretation was supported and agreed upon by the district court and the Court of Appeals in terms of the phenomena of the statements being made, targeting individuals, causing threats to happen to them. I would also add, sir, that in the days after Donald Trump made some of these statements, the district court, in this case, received vile threats to the district court's life. In that environment, I felt a duty as a prosecutor to make that motion, and I make no apologies.
And the court stayed that motion on August 3rd, 2024. I yield back.
Gentleman yields back. I should have mentioned this a little bit earlier. Mr. Smith, if ever you need a break, if you need a restroom break, you or your counsel can just let us know. I think it's now the gentleman from Colorado gets 5 minutes. Mr. Smith.
Can they? Yeah. Can we take a short break?
And I want to stay here for a moment, because this exchange isn't just another partisan food fight in Congress. It's a window into where American democracy actually is right now. Not where we say it is, but where it's being pushed. What we're watching unfold is an effort to redefine accountability itself as persecution. Think about how upside down that is. Jack Smith is being questioned not for breaking the law, not for fabricating evidence, not for violating ethical standards, but for doing the thing prosecutors are supposed to do: interpreting the law, bringing cases, and letting courts decide. That's it. And yet, in today's political climate, that alone is treated as suspicious, as if enforcing the law against powerful people is somehow more dangerous than letting powerful people act without limits. That's the real subtext of this hearing. When Republicans hammer Smith over past cases that didn't end the way prosecutors hoped, what they're really saying is this: if you ever lose, you shouldn't try again. But that's not how justice works. Every prosecutor has losses. Every major legal question gets refined over time. Every serious case carries risk. The alternative isn't caution, it's paralysis. And paralysis is exactly what benefits people who already have power. Now let's talk plainly about the gag order issue, because this is where the conversation gets deliberately dishonest. Free speech does not mean freedom to intimidate. It does not mean freedom to threaten. And it does not mean freedom to undermine a judicial proceeding while claiming immunity because you're running for office. If that were the standard, then any defendant could announce a campaign, and suddenly the courts would be powerless. That's not constitutional originalism. That's chaos. And what's especially telling is this obsession with hypothetical harm. You can't name a witness who didn't come forward. That's like saying you shouldn't put up a fire alarm until the building burns down. Courts don't operate on vibes. They operate on patterns, evidence, and precedent, and both courts found that Trump's behavior posed a real threat to the integrity of the proceedings. Not emotional harm, not political harm, judicial harm. And here's the part nobody wants to say out loud. If any other defendant had behaved this way, this wouldn't even be controversial. Strip away the name. Strip away the politics, strip away the rallies and cable news segments. What you're left with is a defendant repeatedly signaling consequences for people involved in his prosecution. That's textbook intimidation. So when lawmakers frame this as a free speech issue, what they're actually doing is trying to elevate one man above the system that governs everyone else. And that's the line we're being asked to cross. Because once you accept that a former president can't be investigated, can't be restrained, can't be prosecuted without it being labeled political, you've already surrendered the core principle of equal justice under law. At that point, elections stop being accountability mechanisms, courts stop being referees, and the law becomes optional for the powerful. That's not a left-wing concern. That's not a right-wing concern. That's a democracy concern. You can believe Trump is innocent and still believe the process matters. You can criticize prosecutors and still accept court rulings. You can support free speech and still recognize limits when justice itself is at risk. But what you can't do, at least not honestly, is pretend that enforcing boundaries is the same thing as tyranny. Because history shows us exactly how democracies erode. Not all at once, not with tanks in the streets. But slowly, when accountability becomes controversial, when institutions are delegitimized, and when loyalty to one individual starts outweighing loyalty to the system itself. That's the crossroads we're standing at right now. And moments like this hearing aren't about winning arguments. They're about deciding what kind of country we're willing to be. If you stuck with me through all of that, I really appreciate it. Let me know in the comments where you stand, not just on Trump, but on the principle of accountability itself. Hit like if this breakdown helped cut through the spin, subscribe for more deep dives like this, and as always, thanks for watching and staying engaged.